Well, I'd like to start off by welcoming everyone to the Quantum Business Laws Consortium, dealing with issues involving tax law, asset protection, and today we have a theme that will vary somewhat from some of the past sessions. I've noticed that it's just after 1 o'clock, so we'll begin our session. Over the past several months, most of you in attendance today have been following our program, are aware of the fact that we've been speaking with issues regarding how successful businesses and families can protect their assets from creditors, how these individuals can reduce taxes by implementing various different strategies. Many of the individuals in attendance have mentioned that they've faced a lot of challenges that we have. There's an echo in our system. A lot of challenges that have been overcome through the implementation of some of the ideas from the program, which we're happy to hear about. What we have heard recently over the last few months is that there's a lot of companies who are facing rapid expansion, and we've had inquiries and calls from different individuals that have been very perplexed as to how to handle an ever-changing situation where we see companies in the high growth mode, companies whose advisors and accountants and lawyers, many of whom are with us today, are looking for solutions that are either out of reach or completely elusive. Our group has assisted companies in various different areas of technology, deployment of IoT, artificial intelligence, G5 technologies, robotic process automation, blockchain automation, augmented reality, healthcare issues, cybersecurity, just to name a few of the various different issues. So this, I guess, is the silver lining in the COVID-19 cloud, to see that not only are companies sort of bunkering down in order to protect the assets that they've built up over generations, but there's a growing number of companies that have been coming forward that are saying that they would like to help with overcoming the challenge of commercializing their technology, bringing challenges and ideas into reality, developing new technologies at accelerated rates, accurately anticipating what a market will demand, and building infrastructures that will help to create a supply chain and distribution channel that can assist these companies to grow. All of the things that we're talking about today are complicated by the fact that companies don't know how or don't have the capability to be able to fund their expansion. And one of the areas that does work is incentive legislation that's intended to bring cash rewards to companies who are developing their product, their offering, particularly with reference to technology. One of the issues that we find in this area is that this legislation is very difficult for companies to access. Not only that, but we find that companies who are growing are having difficulty getting funding from the banks. The banks these days, as one person recently said to me, seem to be afraid of their own shadow. We've been looking at ways that we can help these companies that are growing exponentially with concepts that can help them to access cash from their company at a lower rate of tax, and also how we can position these companies for when difficulties arise, when there's disputes between shareholders, disputes between competitors and themselves, or with the CRA. At this juncture, we would like to just take a moment, and what we'll do is we'll tell you a little bit about the panel. And as usual, we have a group of very elite panelists with us today that's going to be sharing ideas that I believe that the audience will find very useful. First of all, I'd like to introduce Michael Miller. Michael is a partner with Quantum Business Law, and Michael has over 40 years of experience and is known across Canada for the work he does in litigation. I'd like to introduce Brian Carr. Brian Carr is counsel to Thorsteinssons and acts as special advisory counsel for Quantum Business Law. Brian is very well known as well across Canada and is known not only as an educator, but also an author, a very prolific author, dealing with a lot of different issues involving tax, with resource taxation, tax planning, butterfly transactions, and we're honored to have Brian with us today. We have Gordon Berger, who you've met before, and also you've met Brian and and Michael before, come to think of it, which they're back with us again. And Gord has been in the financial services industry for better part of 50 years as well, and brings a lot of experience to the table. David Ayanoglou. David was the head of mergers and acquisitions for OpenText and has a lot of experience in the area of private equity, finance, and various different other ways that he can help companies that are in the growth mode through COVID-19. We have Mayor Makki. Mayor has significant experience at arguing matters before the Tax Court of Canada and other levels of courts, other courts in Canada. Mayor has the carriage of over 30 cases right now that are before the tax court. We have Louie, who's been effective in working to assist companies in many ways to receive funds through the federal government's program. And without further ado, we're going to jump into this very exciting program, and we're going to talk to you about various different methods that we should be able to help you to access funds. The first is the federal government scientific research and experimental development program, which has existed in its current form since 1986. The SR&ED program, as it's called, is intended to foster technological development amongst companies who pay tax in Canada. That includes all sorts of business styles, corporations, partnerships, trusts, individuals, all of whom the government has set up a program that is intended to foster technological development. The legislation that relates to this is very brief. Jeremy, if I have you display 248(1)(c) on the screen for the audience, please. And as Jeremy's doing that, I'm just going to talk to you about the legislation itself. The legislation in 248(1)(c) essentially talks about the development of products, devices, and processes. And Jeremy, if you could display the slide on the screen, please. While he's doing that, I will paraphrase what it says in 248(1)(c). Essentially, it refers to experimental development. Not now, Armin, not now. Experimental development deals with the development of technology, through experimentally developing a product. We hear a lot of misconceptions, and Jordan in a few minutes is going to talk about that. I'm also going to talk about the fact that not only does it deal with the developments of products, devices, and processes, but it also defines the quantum in which one could develop knowledge in these areas. And that is based on the term incremental. If you're advancing technology, even an incremental advance, it's sufficient to be accepted under the SR&ED program. At this juncture, I'd like to call on Jordan Louie that will talk to us about some of the misconceptions that revolve around that. And afterward, we're going to bring in some segments from Chief Justice BOWMAN, who developed the law in this area through a case called Northwest Hydraulics. Jordan, at this point, if you'd like to please address the audience. Thank you very much.
All right, thank you so much, Todd. And so at this point, I just wanted to share my screen as well. So Jeremy, if you please enable that feature. But I wanted to introduce a firm that's affiliated with Quanta Business Law. The name of that firm is called the Sheldon Group. And the Sheldon Group specializes in the full service preparation and filing of such SR&ED claims. And so as Todd said, I wanted to go through just a number of misconceptions that we've observed during our experiences. And so I'll just share my screen right now. I have a brief presentation I wanted to show. And all right, I believe you can see it now. All right, so the first misconception that we see really often is many people believe that a product must be a brand new invention and not exist anywhere else on the world. And so this one's false, as the important thing or the requirement for work to be eligible for the SR&ED project, for the SR&ED program, is that a technological advancement must be made, and that's regardless of product novelty. And so that's a technological advancement in the same sense that Todd was talking about earlier in section 248(1), and that is incremental improvements to devices, products, and processes. And again, so now the next misconception that we hear quite often as well, many people believe that you cannot benefit commercially from a SR&ED project. It can't be profitable, in other words. And this is false, as there is no such rule at all against claiming for a project that is commercially successful. I would contend that a very large percentage of SR&ED projects or SR&ED eligible projects are successful. And the third one is you cannot claim a project where the product has been sold. And again, so the labor for the project can be claimed. It's the wasted materials, however, that were used to be able to create that product would not, in fact, be eligible to be able to claim. And the next one, many people believe that the work must be completed by a scientist or engineer in order for the work to be qualified. This is false. The work must be completed by a competent professional in his or her field. That's the requirement. And the next one, if a project is a failure or remains uncompleted, it cannot be claimed. And this is indeed false as well. Like technological advancements often result from failed experiments more so than successful ones. There's oftentimes more knowledge that is gained through an experimented process or an experiment where several roadblocks are encountered. And so we were talking a little bit about technological advancements. Like Todd will talk about this further just a bit later, but I thought I'd just sort of offer some clarification as well to this, to the meaning of this term. And so this definition was actually given to us in a landmark case in SR&ED. It was called Northwest Hydraulic Consultants Limited versus the Queen. This happened in 1995. And so the former Chief Justice of the Tax Court of Canada at the time, the Honorable Donald G.H. BOWMAN, I quote him here. He asks, did the process result in a technological advance? That is to say, an advancement in the general understanding of science or technology. And so we see here that an advancement is not a physical thing. An advancement isn't necessarily just creating a new product or a new process necessarily, but it's about acquiring new knowledge in the general understanding about science. It's about acquiring new knowledge about technology itself. That's what the technological advancement is. And further to this, there's a term that many of you might be familiar with. It's called routine engineering. Other words to describe that might be standard practice, perhaps practicing due diligence, for example. And Donald BOWMAN, he also clarifies the meaning of this term as well. He asks, what is routine engineering? It is this question, as well as that relating to technological advancements, that appears to have divided the experts more than any other. Briefly, it describes techniques, procedures, and data that are generally accessible to competent professionals in the field. So that's a requirement that you have to surpass in order to be able to achieve a technological advancement. And so you notice that there are three things that routine engineering is referring to. It's referring to techniques, procedures, and data. But generally, people, they look at the first two terms, techniques and procedures, and they look at their work to see if they may have been using techniques or procedures that are routinely done in the field. But they oftentimes ignore the term data. And so our firm, we believe that, and so data, what does that mean exactly? Data is referring to information or referring to knowledge. And so in our opinion, routine engineering and Donald BOWMAN, what he's referring to was knowledge that was generally available on the public domain. And so that might be perhaps the internet, perhaps scholarly articles, or if you were to ask an expert in the field, a contractor, perhaps an outside engineer about solving a certain issue. And so that's what routine engineering is referring to. It's information that's available through such avenues. And so these two things, they bring us to our firm's interpretation of the definition of SR&ED. And so we believe that SR&ED is the acquisition of knowledge itself that is not generally accessible to a competent professional in his field. And that brings us to this. And so if SR&ED really is about the acquisition of knowledge that is not accessible, then we believe that every single time you're learning something new about science or technology, you're entitled in law to be able to receive funding for those expenses. And so as Todd said, technological advancements can be incremental in nature as per section 248.1. And so it's not only groundbreaking technological advancements that you can claim for, but also small occurrences of knowledge that you gain throughout the year that may be outside of the larger typical SR&ED projects. And so we believe that there are many companies in Canada who are either unknown at performing eligible activity by gaining small amounts of knowledge, or perhaps they may have potential to be able to increase the value of their claims if they are to capture this activity that falls outside of that. And so with that, I'll pass the platform back over to Todd, and he'll delve into the subject further.
Yeah, so I would say that it isn't so much that when you're learning something new, but if you're learning something that is not generally accessible to a competent professional in the field. Having said that, I'd like to invite Jeremy to just display a video for you. So I'm going to introduce you to the Honorable Donald G.H. BOWMAN. And of course, Chief Justice BOWMAN, as he was then called, presided over a case that Jordan referred to called Northwest Hydraulics versus Her Majesty the Queen. And in this particular case, there was a group of individuals from a university in Western Canada who formed a company called Northwest Hydraulics, who was attempting to determine the best method of harnessing power from water, energy from water, dealing with soil sedimentation, erosion, various different issues came up. And of course, this area of science was well established, perhaps thousands of years. They had dams and dikes in Egypt. Having said that, the case that is the best known case and has been heard by every, has been considered and cited in every case that's ever been heard by the Tax Court of Canada and the Federal Court of Appeal, is the subject of this interview. Jeremy, I'd like to ask you to display the video, and as we do, there are three primary reasons that we find CRA wrongly denying claims for SR&ED. One is documentation. Jeremy, if you could please play the first slide. Justice BOWMAN, I wanted to ask you about the issue of contemporaneous documentation. Do you believe that at the audit level, do you believe that contemporaneous documentation should be the basis for determining eligibility, or do you believe that the requirement for documentation should only be evidentiary only? In other words, should be purely to support that the activity took place?
It should be primarily evidentiary, but I'm not saying that it should, that a claim for scientific research tax credit should be excluded if there is no contemporary documentation. There should be. Depends on whether or not the researcher is believed.
You are aware that, and I know that you are, the 5 questions that CRA arms RTAs with, they've taken your 5 questions from Northwest Hydraulics and they've made a slight revision to one of them to say that there's a record of the hypothesis kept as the work takes place, which really has put RTAs in a position where, you know, they're now, at least in many cases, basing the decision on whether the work is eligible or not on the documentation rather than looking at the documentation as being evidentiary only.
Well,
very good, Jeremy.
I would say that the document.
Very good, thank you. I'd just like to invite our expert panel to comment. And of course, we have several litigators with our panel today. And in arguing matters before the Tax Court of Canada, or whether it be dealing with the CRA on matters of tax dispute, the issue of contemporaneous documentation is not a new one. By definition, contemporaneous documentation is documents that are created at the time activity takes place. And whether it happens to be a claim for scientific research or a denial of a deduction for a number of different reasons or any other tax matter, it's something that often is contentious subject. So we've heard what Chief Justice BOWMAN had to say. He said that documentation should be evidentiary, although it's useful. Perhaps I'd like to invite Brian Carr to comment on your experience involving the importance of documentation and when it's not necessarily required in your view.
Well, I think when you're dealing with the audit division, contemporary documentation is always important, in my view. It is often very hard for the CRA to get, for you to get to the CRA to look at anything else except documentation that was created at the time. At the audit stage, you certainly don't have the ability to start presenting witnesses to them, they'll listen to. The CRA has a basis belief that documentation evidence is the only evidence that's worthwhile. So if you don't have contemporary documentation, you're going to have a very, very tough time with the audit group. With the court, you get a little more leniency. There are judges up there. They understand that evidence can consist of documentary evidence and also oral evidence and what people say. So you're not really stuck with just the evidentiary documentation. At the same time, you're in an area where if you're doing scientific research, one would think that you're going to have some notes, some preparation showing what the results of your experiences are. My own background is in physics and chemistry at the undergraduate level, so I sort of sit there and say, well, you did an experiment, you had to write down the results somehow. You don't expect scientists not to have the documentation. So it's going to be an uphill fight if you don't have contemporary documentation. I always say, just as a general litigation matter, I tell planners this, as well as litigators, you're doing a transaction. There's perhaps a weak point in your transaction. How are you going to justify, how are you going to prove to a court at some point in the future that you've satisfied a particular section? What evidence are you going to have? Therefore, when you're doing the transaction, you should be preparing the evidence as best you can, whether that's memorandum to file or some other contemporary documentation that you can pull out at the time that you get challenged by the CRA and you find yourself in court. So same answer goes to the scientific research and ED area. Prepare your documentation at the time and be prepared to present it to the CRA and the court when the time comes.
Yeah, I think it's needless to say that documentation is always important. It's always the very best method. The problem is that it isn't always the case, that companies have kept the kind of document that CRA may like, as an example. And at times it becomes a moving target. And the other issue often is that when claims are being rejected on account of not having sufficient documentation, it isn't always a question of whether or not the activity took place. It's a question of whether or not there was, say, a technological uncertainty, or whether or not there was a genuine advancement. And as Brian mentioned, I think it's reasonable that when you're doing experiments, it should be expected that a clinician or a technician or anyone who's involved in that kind of work would do things in a disciplined way. So by no means are we suggesting that documentation shouldn't be kept, but the standard for documentation is one that's difficult to determine. Perhaps Michael Miller, I would ask you as a civil litigator about the issue involving contemporaneous documents and your view of perhaps recreation of documents that are intended as a summary of past events in lieu of contemporaneous documents, and what your experience might be.
Yeah, contemporaneous is what's important. If you recreated it, the question is that done by a lawyer to make it easier for a judge? And if so, does the other side agree to have it put forward as evidence, and or at least of what the argument's going to be? So it's what happened at the time is the best evidence, and how it was recorded. That's what's important.
Very good, very good. And Mayor Makki, I'd like to just invite you. I'm thinking about 116976 Canada. And of course, I believe it was Justice Somerville who stated that it is possible to adduce eligibility based upon oral testimony, but one puts themselves, as he put it, in a precarious position by relying on oral evidence. I'm just curious, Michael, Mayor, what your view would be as far as documentation and the level of documentation that should be for any tax matter whatsoever.
So in terms of SR&ED, if we're talking about SR&ED, you definitely need, if you're doing experimentation, it's prudent to, like Brian Carr stated, that it should be somewhere. Now, if you don't have it, nowhere in the act for SR&ED does it state that you have to have documentation. You could, if you don't have it in tax court, like Brian Carr stated, they'll be more lenient, and you could draw that in testimony when you call your expert or your client up to the stand. You could draw what they did in testimony. Moreover, in electronic health records, Madam Justice did a good job at explaining this issue. Let me just read what she said. She said, while it's always preferable that an appellant maintains contemporaneous documents to support its systematic investigation, the Act contains no legislative requirement to file those documents in order to qualify for deductions of expenditures. This is not to say that taxpayers should ignore detailed record keeping. Such documentary evidence is always to be preferred in each case. Now, documentation isn't always your test results. Sometimes we've had cases where a robotics client was trying to create a camera for reflection. It was very unique what they were doing. So what we had was 1,500 pictures, where if you see two pictures together, it looked like the same pictures. But when you put all the pictures out in front in this diagram, you see the different iterations they were going through. So pictures, it wasn't the testing, but the pictures proved the testing. So sometimes it comes in different shapes.
Yeah, I think at the end of the day, the consensus is, although documentation is important, it isn't necessarily the determination for eligibility. It ought to be evidentiary, but without that, it's very difficult to adduce credibility. Jeremy, I'd like to ask you to continue the video, please.
Documentation is the strongest evidence that you have in many cases. So try to have it, but I'm not saying that it's essential that I would reject scientific research claims just because there is no documentation. It depends on what they believe the taxpayer.
Chief Justice Bowman, CRA has taken the position that trial and error is not eligible for SR&ED. Is this semantics, or what do you think about this position?
Well, I think that's baloney.
Please.
I don't.
I'd like to turn back to the expert panelists for a moment. You heard right from the horse's mouth, not that I would call Chief Justice Bowman a horse, but with all due respect, the question was asked, is trial and error eligible for SR&ED? I can remember in the case of Joel Theatrical, I don't recall the judge, but the comment was he doesn't recall whether or not that there was any cases that specifically stated it wasn't, but he could have seen how it was. I was thinking, anyway, without further ado, I'd like to call upon the expert panel to talk a little bit about this concept of trial and error. Before I do, I would like to share CRA's view of what trial and error is. And in effect, they tend to maintain that trial and error means that you're doing something haphazardly. You're doing something without the guidance of a hypothesis. You have not presupposed what a result would be and worked toward the end, which we can understand. So I guess the question is it semantical or is there substance? Is there any reason? And I think part of the problem is that scientists and engineers often use the term trial and error to describe what others might refer to as experimental development or research that would involve experimentation that would include a hypothesis. Just curious, your view on this expert panel.
Well, I guess it is a bit of semantics as to what you mean by trial and error. If you're just haphazardly playing around in the lab, throwing this component in with that component and hoping for something, well, maybe that's not really scientific research. I think of trial and error as a scientist that you have a concept of where you want to go to, and you're trying to prove that. And sometimes you get there and sometimes you don't. And sometimes you come up with unexpected results which are very favorable. I'm thinking of the sticky notes. That person was starting off trying to develop a glue, and he found out that the glue didn't work. But he developed something far more valuable than the fact that glue had worked. Viagra is another example of a drug they were trying to develop as a heart. My understanding is a heart drug. Found that it didn't work, but it had very interesting side effects. So, I mean, if all you're doing is throwing things around in the lab again, that's probably not scientific research. But scientific research is really a trial and error. You start off with some idea of where you want to get to, and you try to prove that you can get there, or you find out you can't. And that's really, sometimes you get a lot of times when what you thought was the what you thought was going to be the result isn't in fact the result at all.
I think that in general, throwing darts blindfolded is not SR&ED. I mean, the apple falling on Newton's head, well, it just came to him. How is that SR&ED? I don't think that the suggestion is that it is, but oftentimes the problem is companies who are performing what they believe to be trial and error could well be eligible work. Perhaps Mayor Makki, I'd like to ask you to comment on the notion of trial and error in your experience.
So I think one good example is if I have a piece of wood and I'm drilling into the wood to see which screw, the size of the screw best fits, and I keep trying different screws to see which one goes into the wood the best, that to me would be trial and error. Versus if I have an idea, what Brian Carr alluded to, my hypothesis, following, if you see the work, the systematic investigation going towards your original idea of your hypothesis, and you're trying to find answers to your hypothesis, that would be more of a systematic investigation.
I would suggest the scientific method is one that embodies a hypothesis. And if in doubt, it would be always prudent to consider whether there was a hypothesis that guided the work that was intended to either modify or confirm a hypothesis. Part of the question, I think that the issue that relates to this is that oftentimes when claims are being adjudicated by the CRA, they present 5 questions. And at times we've seen it presented as the 5 questions in Northwest Hydraulics, as stated, presided by Chief Justice BOWMAN, as he was then called. Well, question 5 has been changed in CRA's guidance documents. It states, was there a record of the hypothesis kept as the work took place, versus was there a hypothesis? It really relates back to this question of contemporaneous documentation, dealing with the a quantity of documentation and the granularity of documentation. So we see there's a connection between the two issues. Jeremy, if you continue the video, please.
Believe it at all. I think that trial and error is one aspect of the type of research that goes into scientific research.
I think what they're attempting to say, and of course, I think what CRA has done is they've taken the term trial and error and they've created their own rendition, their own definition.
I don't have any doubt, for example, that Thomas Edison engaged in a lot of trial and error.
Undoubtedly. Good analogy. I would suggest that what they're really saying is there's no hypothesis that guided the work. But the term trial and error, and of course in Joel Theatrical, Justice Somerville had mentioned the same subject and said that he didn't know about any jurisprudence that stated clearly that trial and error wasn't eligible. So again, I think...
No, I agree with that, yeah.
Would you say there should be more training in this area for CRA officials?
They shouldn't need training, for goodness sake. They should be able to reach that conclusion on their own.
Well, how about that? How about that? Listen, I mean, CRA does a very good job at administering the SR&ED program. Certain things are logical, and oftentimes individuals who are purely academics are involved in making determinations on things. And always I recall Chief Justice Bowman's words that things often, an uncertainty is in the mind of the performer, and it may not be obvious to another person. Who is it who could make a determination that someone didn't have a hypothesis? I think as adjudicators, whether it be an auditor or whether it be a judge in the Tax Court of Canada or the Federal Court of Appeal, I think one of the questions always has to be is the basis for eligibility based on this whole question rooted on the basis that there is a hypothesis that guides the work. Jeremy, I'd like you to continue, please.
Which includes incremental improvements, was there to fill a gap, or what was perceived as a gap in the legislation. In other words, the CRA was, I think, erroneously, taking the position that if there was something already invented, but they were improving on it, that was not experimental scientific development. And I think in the definition that I had, I used the word infinitesimal improvements.
Yes, you did.
And I think that what I meant was to comment on incremental improvements there too. In other words, it didn't have to be a brand new product. It could just be an improved one.
The concept of novelty is an interesting question, and it's one that you'll very seldom ever connect to SR&ED. Whether or not a product has to be brand new is one question, but I think a more important question is how much knowledge do we have to gain to be eligible? Brian, perhaps you could comment on your view of the quantum of knowledge one would have to gain in order to be able to take a position they've indeed advanced technology.
I think that depends upon, obviously very factual dependency, but you have to show, I suppose, that there is some element of research that, for example, maybe you have a camera that can take 30 pictures a minute and you move it to 60 pictures a minute. What enabled you to do that? Did you have to discover something mechanically that allowed you to do that? Or was it just adding a bigger roll or something? So I think there has to be some small scientific change at least that allows you to produce a better widget, but it doesn't have to be huge. And something that, some work that gets you to that result will be scientific research and development.
Very good. And Mayor, your comment on the use of a term that Chief Justice BOWMAN, as he was then called, used to describe the quantum of knowledge.
I think in Northwest Hydraulic, he said infinitesimal knowledge. What was, I think, 0. I don't know the number, is very small. Knowledge is advancement in knowledge. And just to note too, a failure is considered an advancement in knowledge. So sometimes you'll have different iterations and you'll have small incremental advancements or small failures, but you haven't resolved the whole uncertainty. So if you failed at a project, that's considered advancement too.
Yeah. What about the fact that there's a body of knowledge that exists and we're adding to it? The term incremental, one would have thought would have been enough, that existed in order to describe that something that's incremental is added to something which already exists. So I believe that what Justice BOWMAN had done is he had actually defined that the amount of advancement in knowledge must only be slight. And I think that's our takeaway. Jeremy, the next part, please.
Definitely. I think the incremental implies that there be an addition or a minor improvement even. I can't imagine what known techniques would have been used by Thomas Edison when he invented the light bulb. And yet, no one would question that was a breakthrough experimental development. Well, routine engineering, standing by itself without the benefit of a statutory definition, is it's pretty routine. It's pretty there's nothing unusual about it. That's why that people disagree over it. I think it's a high time that they looked at the definition of routine engineering as including aiming at at least a result that is not predictable.
All right, so let's stop for a moment, because one of the issues involving routine engineering is where things are not reasonably predictable. And this is in Northwest Hydraulics when the question was asked rhetorically by Chief Justice BOWMAN, what is routine engineering? And he said, briefly, it describes techniques, procedures, and data that are generally accessible to a competent professional in the field. Previously, it mentions the concept of reasonably predictable, whether a problem could be resolved where the result was reasonably predictable. Well, what does that all really mean? All too often, the government is denying claims for scientific research on the basis that the work is classified or trivialized to be routine engineering. And of course, this is an area where there's a lack of understanding. And according to Chief Justice BOWMAN in his decision, he said, no other term creates more controversy amongst the experts than the use of the word routine engineering. And of course, he said that briefly it describes three things, these techniques, procedures, and data. And we'll hear what Chief Justice BOWMAN has to say about those three things in a moment. If one of those things are missing, could it still be routine engineering? Jeremy, please.
You've went on, this is the second part of your explanation about routine engineering, and you've described it this way. Briefly, it describes techniques, procedures, and data that are generally accessible to a competent professional in his field.
Yeah.
Seems to me that the underlying meaning of your decision would have required a great deal of thought in coming up with that.
I don't remember whether I did any thinking or not, but I can assure you, yes, I did.
Yeah.
And remember that routine, I meant, was intended to include techniques, procedures, and data. In other words, methods and information.
What was it, Jeremy?
There you go.
Okay, so we're talking here, Chief Justice BOWMAN was just about to refer to routine engineering. And the fact is that we see routine engineering as being akin to a three-legged stool. It may be that your company, if you're a lawyer or an accountant, your client, had resolved the problem using known techniques. It could be the procedures were known, but the data is the third part. The definition for routine engineering is techniques, procedures, and data. What is data? Data is knowledge. Data is information. And it may well be that the techniques and the procedures were known, but what about the information? What about the data? Was it known? And in the event that you were to consider the work that was undertaken, was there information that was learned? Well, that would imply that there was information that was missing, that was needed in order to accomplish the objectives. If we're able to finish the video, go ahead, Jeremy.
What's interesting is when we see a decision coming down from CRA that says the work was not qualified because standard procedures were used to resolve the problem, what part of that, of your decision, do you think they might be ignoring?
Well, they did not give sufficient, in my view, sufficient effect to reasonably predictable. I think that if there's reasonable predictability, the fact that only routine engineering is utilized in reaching that conclusion, I do not think disqualifies the scientific research.
Yeah, continue.
Do you believe that the entire question of eligibility not only is based upon developing techniques that didn't exist, but perhaps choosing from existing techniques? Could it be that there are 3 or 4 or more techniques that are known, but without experimenting with them and seeing how they affect each other, would you say that that would constitute a legitimate uncertainty?
Oh, I should think so, yes. Why not? You don't know the result that you may use routine engineering procedures, but you don't really know what result you're going to get.
Okay, continue.
One of the points that we have made is that the definition for routine engineering must be supported by what would be akin to the proverbial three-legged stool. You have techniques, procedures, and data. And without these three supporting legs, the stool would topple.
Yes, because the third leg is an integral part of the stool.
All right, so I guess we want to just step back for a moment, and whether or not we're talking about getting money from the government or dealing with issues with CRA, which invariably will affect any fast-growing company at a certain point in time, I'd like to turn it over to the panel to discuss how you resolve issues. Perhaps, Brian, I'd have you kick it off with the various methods that you use when you typically resolve matters, first with the CRA and then with the Department of Justice, and possibly what an expected outcome would be, when is good to go to court and when is not.
Well, I find, I think I mentioned before, I find with the CRA, you really have to have documentary evidence to support your position. They're at that stage, they're, I won't say in all situations, but in most situations, they're not particularly interested in fancy legal arguments, so I can be pejorative for a second. They just want to see the facts. And I think that you have the most success at the CRA level if you can show them that their understanding of the facts was not correct. That you can show them factually that they've missed something or there's something else they should be looking at. If what you're saying to them is that you agree with their facts, you just disagree with the law, I find it very hard to convince CRA to back off. Then when you move it up to the Justice Department, there's a lot more play in there. First of all, they are lawyers. They appreciate the legal arguments, and they're much more likely to give you some, give you a hearing on the law as opposed to simply the facts. So yes, you still need the documentary evidence, but you have an opportunity to convince them that they're wrong on the law, or that there's at least some doubt on the law. A lot of the times you're trying to saw it off, so you don't have to hit it out of the park. You simply have to show that your argument has some merits to it. Going to court, when to go to court, I mean, that's sort of, it's always a very difficult judgment. A lot of it is how much is involved, what is the cost going to be to go to court, what's the likelihood of success. Sometimes you have to, with your client, come to some kind of, I guess, mini guess as to what the likely outcome is. It's never very, I had a principal who said, there's no case so bad that you can't win it, and no case so good that you can't lose it. So you have to try to evaluate as best you can what you think your chances of success are before you press on to court. I don't know if that's a response to your question. If you have anything to follow up on.
I would say that I quite agree. I would further say that clarity is also important. In the event that you do go to court with a matter, whether it be scientific research or any other subject, making your position clearly understood, I think, is critical. If a judge doesn't understand, he's no different than an auditor from CRA. The easy thing to do is to say no if they don't understand. Perhaps, Michael, I would ask you for your view of how to state your case in a way that clarity is achieved. How do you identify the key matter, and what are you asking the court to do, and how do you do it?
Thanks, Todd. Well, you have to be good at what your trade is. That's how you sort of learn what a good case is and what isn't. Presentation is very important, both in tax court and in civil litigation. It's clear that judges do not want to hear 5 different key things. They want to hear 3. You have to give them your best 3 up front, make it a fair and reasonable and understandable argument. The other arguments waste time. So obviously sometimes you can have 4, but you don't want to overload a judge on facts that aren't going to be relevant in his or her decision making. So that's the same thing here as Brian has just said. Well, in my opinion, it's preparation in any event. And if you're dealing with scientific information, you've got your experts to talk about that. But in other forms of litigation, well, you have experts as well, but usually it's the lawyer herself or himself.
Now, Brian, I recall that as a chairman of Tax Law for Lawyers, you had recited an account of Chief Justice BOWMAN doing a presentation at the Ontario Bar Association program and stating about your closing remarks. Maybe you could recite that.
Well, yeah, I can't remember the exact words, but I'll give you two things here. He was talking about cross-examination, and he said it has to be swift, bloody, and deadly. And if it's not all those, it's not worth doing. I remember a particular case where my client admitted to me just shortly before trial that there was a certain weakness in the case. And he said, well, what happened if the Crown asked him that question? I said, well, you've got to answer it honestly. If you're not honest, you've lost all credibility. Well, the Crown lawyer was one of those people that seemed to hammer every question home and really didn't get to the meat of the matter. And so about 2.5 hours into her cross-examination, she got to the question. Well, you can imagine by that point, the judge had lost a lot of his interest, and the question had no real impact whatsoever. Had she set it up and asked that in the first 10 or 15 minutes of the cross-examination, it probably would have been devastating. So that's an example. Don't waste a lot of time on going after peripheral matters. Figure out, at least on a cross-examination, where the heart is, and go grab your dagger and go for it. Mr. Justice Topinka had a comment I've always remembered, dealing more with oral advocacy. The three B's of oral advocacy: be brief, be concise, and be gone. So make your point and don't belabor it. Make it and get on with it.
Yeah, as far as cross-examination, we were just chatting before the program, and there was a case I had argued where I was asking for an individual to be accepted by the court as an expert. And this individual had displayed an attitude that I was interpreting as being somewhat of an elitist viewpoint. And I took a chance because I kind of broke a cardinal rule on asking a question that I didn't know what the answer was. But I thought I did, and I was right. I asked him, have you ever been wrong? And he said, no. And of course, he was not accepted as the court through order and being accepted because Crown Counsel had opposed my request to the court to have him accepted as an expert witness. And but anyway, to that end, we would like to make a point as a group, and that is, and I'd like to I'll turn it into a question. Is CRA always right? I'll turn that over to my expert panel.
Well, I think the obvious answer is no. They're quite obviously not always right. But you can't be so dismissive of them as to think there isn't some merit to their position. I think when I'm trying to prepare for a case, I always take into account what their position is and how I can meet that position. I guess it's a question of never underestimating your opponent. You don't want to overestimate them. You don't want to become so scared that you're not prepared to do certain things, but at the same time, don't assume that they can't prove things or they don't know things. That'll haunt you. So it's a proper balance of respecting them without giving them too much respect.
Yeah, I think that the reason I presented the question the way that I did is because oftentimes the pronouncements of the CRA is interpreted as fact by taxpayers. We've heard companies say, accountants, lawyers, we've heard people in business and industry say, oh, it's not correct because CRA said so. And I agree with Brian. There are some, oftentimes they are right. But like anyone else, they can be wrong, just like you or I or anyone else can be. And the fact is CRA does not make the law, they interpret it. And they utilize their understanding of the law. And it isn't always that the courts agree with them. And there's instances where legislation has later been changed because of court cases that have, in some cases, had an outcome that in the mind of CRA wasn't right. So they can go from not being right to right as well. So respect, yes.
You like quoting Chief Justice BOWMAN. Well, remember him once saying before a panel at the Canadian Tax Foundation, commenting on a case, does that make any common sense at all? So if the position of either position, either your position or the position of the Crown does not make any common sense, then I think the answer is to stand back and look at it again. If it's the Crown is taking a position that makes no sense, then you know you've got a very good chance of success. If you can stand back and look at your own position and say, well, it has no common sense to it, I think you should realize you've got an uphill battle.
Perfect, perfect. Very good. Thank you very much, expert panel on the litigation side. At this point, we're going to change gears and we're going to be talking about ways that we can assist companies in high growth industries through acquiring financing. We have had many inquiries of companies who are attempting to globalize their operations, to scale up their distribution and to exploit technology in a way that can put them on the map. And there's various different solutions in a climate where oftentimes financial institutions, particularly banks, are being cautious on account of COVID-19. It is interesting that there are lenders, there's equity investors who are interested in assisting companies, who are interested in promoting their product, their services, beyond the boundaries of Canada even. In Europe, there is negative interest rates that currently prevail. Bond yields that are paid in England are essentially, in Europe, are essentially nil. So one of the issues that we have been able to identify as a way that we can help companies is that there's relatively low interest lending financing that can be made that has equity components, where interest rates as low as say 3 to 4%, guaranteed for at least say up to 15 years is certainly possible through some of these lenders. And to that end, I'd like to invite David Ayanoglou. David, perhaps I could have you just address the audience a little bit, first of all, about some of the finance opportunities and what some of these opportunities would look like to a company who's interested in exploiting their technology.
Yeah, thanks, Todd. So I guess one of the first things one should consider is who the right financing partner is and what that financing partner would require in order to approve given a financing set. So financing partners typically look for collateralization, the ability to debt service, and then to the extent that they're going to take an equity stake, they're looking for growth, scalability, and sustainability, and an exit strategy. So those are things that when you're approaching a financier, you want to be thinking about, because you want to be able to answer the questions that are going to be on their mind.
Yeah, so David, when you're talking about scalability and sustainability, those are all very important factors. But what sort of upside would there be? I mean, you're talking about an exit strategy, you're talking about how you're going to get there, but perhaps you could describe some of the exit strategies that exist.
Yes, so depending on who your financier is and what kind of financing you're getting. So the exit strategy, obviously, for debt typically is the repayment of capital. The exit strategy for a private equity type of financing, the private equity realm typically holds their investments for 3 to 5 years, and they're looking to, I'm going to use the polite words, dump their investments after that period, and they're looking to make a clip on that. So typically that involves a sale process to another buyer.
How important do you think it is that, say, intellectual property is patentable, David, in your view, if you were thinking of a financier that was looking to work with a company who was interested in taking their business from a local Canadian company to a company with international distribution? And I realize that oftentimes the amount of money that's needed, the banks aren't really that interested. I mean, I know there's been situations where there's been financing ranging from $50 to $250 million that's been made available to companies in these situations. And in that regard, what would you say would be the type of industry or the type of opportunity?
So with respect to patents, especially if it's in a tech space, high tech space, I would say you need it. If the financing is happening for a type of lab that's doing contract work, then a patent will be less important. But it would be that kind of target would attract a different type of financing. Especially if there's going to be some type of mezzanine financing where there's a conversion option, obviously the financier would require some type of reassurance that the technology is proprietary, or an equity investor also the same, because the last thing that an equity investor or a mezzanine investor would want is to get dragged into IP litigation, patent litigation, as some in the expert panel know.
Yeah,
It's
so
dangerous ocean to swim in.
yeah, and what about risk tolerance that typically these investors would have? I mean, how would you define that to anyone who in attendance may be interested in that kind of financing?
Yeah, risk tolerance depends on the industry again. We're sitting, like you mentioned, about the fact that Europe is sitting in a negative or near negative environment for returns. I'm going to put it to you that North America is not that far behind them. So there's a lot of investors that have patient capital that are looking to deploy it and are not able to deploy it themselves. So there's opportunity, there's appetite, but no one's going to make a stupid investment. It's got to make sense, and it's got to be protected by either patents, a really good brand, or a reason for the investor to believe that there's sustainability there.
Yeah, so as far as exit strategies, there's a few. There could be an IPO, there could be a sale. What kinds of outcome would you think that a lot of these financiers would be looking at as being more favorable? Or would it be industry by industry, case by case? Or how would you look at this, and what would the upside be if you could give us an example?
Yeah, so I think it's on a case by case basis. Many companies have IPO'd, have gone public prematurely, and much to their demise in the future. So and sorry, Todd, I know you got to go, so I'll just keep it short. I just think that it depends. It's on a case by case basis. As each business differs and each stage of each business differs, one might be suitable for an IPO. One might be suitable for a wholesale sale. And so I'm not sure, given the timing, I probably can't get any more granular than that, but it's on a case-by-case basis, I would say.
Yeah, perhaps Gord Berger, if you're there, you could maybe give us your comment and your experience on the appetite that some of the financiers might have for these types of opportunities in the high-tech space.
Well, basically, the financiers that I have dealt with in the past 30 or 40 years, the first thing they want to know is about management, about the people who are actually driving the company. And that's where it all starts, unless you're asset-based. If you're asset-based, obviously, it's you're looking at what the assets are. But generally speaking, they want to see if they are given a loan, how it's going to be implemented, how the company's going to use it, how long it's going to take. Like, there are 39 questions that have to go before any lender is going to actually write a check. And then you get a term sheet, and then you have to see if you can do that. And then there's an engagement letter, and then you have to see if that melds with what you want to do. And you have to see also what you're signing. Yes, I always say to people, having done this for a long time, the devil is in the detail, right? And the detail sometimes is not in the original discussion. So there are a lot of, and you have to employ a business lawyer and business accountant, I believe, that have done this before and who can counsel you through these loans, because if a loan's done on the wrong premise, you lose the company.
Yeah, what about restrictive covenants and how
well, yeah,
compared to the bank?
Covenants are you basically can't go out and get any other money. You basically if you're borrowing enough money, they want to run your company, but But from the operator's side, he wants to know that the original deal, they did their diligence, the lenders did their diligence, and they're going to let the board and the chairman and the president and the operators run the company.
Yeah. Okay, so
Um,
there you have it. We've got a few different ways that companies who are in high growth modes can get assistance from the federal government through the program that we've described, through private equity arrangements, through financing, non-traditional financing that is most unusual that we've described. Now I'd like to move to Michael Miller, and I'd like to call on Michael Miller to talk about how companies in the high-tech area can protect their intellectual property where there's a patent and where there isn't a patent. Michael, perhaps you could speak to that.
Okay, thanks. The only real protection you have for those type of businesses is a patent. It's unassailable. It's the first thing that someone would look at, and is the best protection you can have. It's good for 20 years, which means at the end of 20 years, the whole world has access to it. So you can't sit for 20 years and think you're going to be happy on the 21st year when everyone else is using your product knowledge. Patents have to be useful, and you have to be the first in the world to get that patent. And it is, as we mentioned earlier, for products or composition of products and machinery, and even that minor improvement is patentable. It's a race to get your patent filed, because first one in is the one that wins. So if we're talking, for example, about a shred, and we see that it takes, in some cases, years to develop that invention, that difference, someone else may be doing the same thing, who could be a month ahead of you or 6 months behind you. So you want to get the patent as quickly filed as possible. There's other ways too. There's something we mentioned, Todd mentioned industrial designs. That's different than a patent, but it's still strong and is fairly easy to enforce. If it's a configuration or a shape or a pattern or just a bow put on a ribbon, that would be an industrial design. You can file and register. That registration is only good for 15 years. And lastly, it's what I think Brian was referring to is trade secrets. And trade secrets are where you develop this new technology or new innovation, but you don't want it to expire in 20 years. So you keep it as a trade secret, and then you license it out to other parties who are paying you for the use of that product, or you're keeping it a secret within your own company. Trade secrets include anything that you've developed that someone else hasn't developed. The problem with a trade secret is that you're not registered, and someone could either through just straight luck develop the exact same product and patent it, and then you'd be out, because the first one to register is the one that has the patent. So you have a risk with trade secrets. It's hard to keep them secrets depending what the secret is. The makeup of a Coca-Cola is a secret, and they wouldn't want Pepsi to have it. So they keep it as a trade secret, and it's patented as well, but they keep it locked up. So it's important to do this as quickly as you can. You can't rush it, but don't dawdle. As soon as you can register, and the patent is the safest way to do it.
Yeah, so Michael, in the absence of a patent application, in the absence of seeking a patent, if individuals have contractual provisions that would take into an account ownership of intellectual property and the capability to exploit that property, what can companies do when they collaborate with other technologists or suppliers or anyone else that they endeavor to advance technology with, where there's been an infringement upon their intellectual property? How can they best protect themselves when they collaborate with other companies that are involved with the development of similar ideas?
Yeah, well, get a good lawyer. is always a good thing. It's very hard. In the example you just gave, both of them were unregistered, correct? And if that's the case,
The Jeremy Louie 185 calling now.
okay, we just saw Gordy's bar mitzvah picture where he had hair.
Yeah.
So what I'm saying is, if you can show that you're using it, and the other party's using it, and you don't know it, it's first come to register.
Okay, very good. Jeremy, I'd like you to explain to display the chart that we had talked about before. And as Jeremy's displaying that, we're going to talk about ways that we can assist companies who are in high growth stages to mitigate the tax and to, in the long run, pay less tax in the meantime. And the scope of this discussion is going to be rather limited today in the interest of time to what can be done. So in the past, we've talked a great deal about estate freezes. We've established the fact that when we die, the assets that we have are deemed to be disposed of for the purposes of calculating capital gains taxes. We've discussed that intergenerational tax planning is predicated upon the use of instruments such as trusts and other vehicles that can be established in order to achieve various different roles. But as companies grow in value, and exponentially so, then it's very important to determine what will be the tax impact during a liquidation event. David had mentioned a couple. He mentioned a company going public, issuing an IPO. We talked about the sale of the shares of a company. There's a tax that's generated at the during an asset sale, as there is with a share sale. So how can a company position themselves, or an entrepreneur, to enjoy the best result from a tax point of view? So here we have an example of what we call an insured estate freeze with tax reduction. And essentially, we have a situation where we have this very successful company who, despite COVID-19, is doing very, very well. And this particular company has an enterprise value of, say, $10 million in their company. The value of their active business. They've accumulated redundant assets or surplus cash to the tune of about $5 million. The current fair market value of this company is $15 million. What we maintain is, if this is the situation, which it often is from some of the attendees that have been calling us, the lawyers, the accountants, and the business owners, saying, what do we do next? How do we reduce the effects of tax? Well, just to kind of lay this out for you, if this company doubles in value, clearly the value would be $30 million. And the tax effect on that would be $7.5 million. So in other words, at the time of the sale of the company, at the time when the company goes public, when the individual dies, when they sell the shares, there's significant tax of $7.5 million, which is 2 columns over. If the individual was to perform an estate freeze, what it really means is that you're exchanging your common shares in the company that grow for preferred shares that don't grow, having the effect of freezing the value of the company at $15 million. The interesting issue here is that oftentimes the presence of the cash inside of the company creates problems that the entrepreneur is unaware of, and oftentimes no one ever tells them. But the first problem that this company would have is they would have a loss of the capital gains exemption. The Income Tax Act provides that all or substantially all of the assets of this company should be actively used. And since in the case of the value of the surplus cash, there's $5 million there, it would be highly unlikely that the company would have any eligibility for a capital gains exemption, resulting in future tax liability, should the company double, of about $7.5 million. And that would be assuming no capital gains exemption. And the next column over in blue, if there were an estate freeze at this time, so in other words, if you are a lawyer, an accountant, or you happen to be a business owner who's doing very, very well, whether it's your client or your business yourself, when is the best time to effect an estate freeze? Well, perhaps you can answer for yourself, because if you do nothing, your tax liability is $7.5 million. down the road. And there are three eventualities, one of which is you could sell the company. Second, you could pass it on to the next generation. The third, unfortunately, nobody gets out of this world alive. So the tax liability would be reduced from $7.5 million to only $2.8 million, meaning that companies that are growing in value, who would expect this kind of growth, which is not uncommon, could save in the ballpark of $4.6 million through an estate-free strategy. The next concept that I'll just mention very briefly here is that there are ways that tax can be reduced when it comes to using what we would call an insured estate-free strategy, and where an individual would not have a requirement to take money from a company, but could access funds on a basis that it's done through a leveraged arrangement that would eliminate the need to pay tax if they were accessing the money from the company. And maybe I'd have Gord Berger just amplify a little bit on how that works.
Thanks, Todd. So generally speaking, the target for this kind of strategy is a company that has a lot of retained earnings, tax-paid surplus. It has an owner-operator professional that's probably under 60 and is doing some succession planning, and they're trying to wonder how to get money out of the corporation for their personal use, because even to send your kids to school today, if they're going to university or whatever, it takes $2 to end up with $1 so you can pay the fee if none of the tuition is deductible. So we have a structure. The structure basically is, by way of example, if you took $1 million out of a corporation in most parts of Canada, by way of dividends, by even the cheapest way possible, you'd end up paying around 50%. So on $1 million, you'd pay $500,000. You'd have $500,000 left. And so that is basically what everybody's facing, over probably $500,000 of dividends. So what we do is we take another strategy. The strategy is basically, if the prospect or client is insurable, we insure them for, let's say in that last example, $1 million of annual premium, that is every year. And at the same time, we get them aligned with a bank which will offer them leverage, basically to the tune of the cash value in the life insurance policy at any time. So basically, if you write a check for $1 million corporately, we're going to have a bank, could be Scotia, one of the top banks. They'll lend you money at Bank Prime, and the loan under age 60, because it gets a little more leakage after that, would be about $950,000 the first year. After the second year payment, it'd be about $975,000. Third year payment would be about $1 million, and then it goes the other way, even to the extent of, in the 11th year, which is interesting, if the corporation pays a premium of $1 million, the cash value will go up by $2 million in that instant on the books of the corporation. So now you have, going back to the first year, a loan, and just so I can make it easy, instead of saying it's $950,000, it's $1 million, and we can offer the loan to either the corporation to pay back the premium, or we can actually offer it to the shareholder or professional shareholder. And in order to ascertain that, you basically ask the question, if I gave you the opportunity to have $1 million, would you like it back in your corporation, or would you like your hot little hands? Well, 99.9% of people say, geez, I'd really like to have it in my hand, because you're not paying tax, it's just a loan. However, you have to follow some rules, and one of the rules is you're going to be paying interest, and today the interest is 2.45% Bank Prime. So on $1 million, that's $24,500. But you're also under three provisions of the tax code, three sections of the Act, 15.1, 15.2, and 56.1. To note, you are expected to pay a guarantee fee to allay the possibility of a taxable benefit on the fact that you're using the cash in the contract in the corporation as collateral for a personal loan. End of story. So now you have $1 million, let's say, in your hands. You've decided to take it personally. You have to pay interest. The interest is $24,500, as we discussed. And the guarantee fee can range from anywhere from 0.5%, 0.05%, or 1%, or maybe 2%. So I choose to deal with people to keep it very simple that could actually go to the bank and borrow the money anyway at Bank Prime. So you'd have the bank lend the money to the entrepreneur or professional. I'm sorry, my screen is falling for some reason. There we go. Sorry. And so what happens is you have the $1 million. You paid roughly a 1% guarantee fee from your loan to your corporation. So it's not even out of your pocket. Nothing's out of your pocket. And now you have, if you consider the interest on the loan, bank interest, and the guarantee fee, of about $965,000 left in your pocket. You should take money that you want to spend. Now remember, when you were getting income, you were paying tax. Now you're not paying tax. So you can take up to $500,000 in my simple example, and you can spend it. You're going to have more net spendable money, but the other $500,000, I insist with my clients that they invest it either back in their business by setting up a shareholder's loan of, let's say, $500,000, putting a PPSA on it, so to secure it just behind any bank debt, if there is bank debt, which there may be, and before any unsecured creditors. Or you can make investments in other things. A lot of people like to invest in land, whatever, but it should be pretty conservative. And what we say is we try to match the investment that you make by discussion purposes on the deemed interest rate that CRA would put on you if you had to repay the tax. So what I've looked after, which virtually no tax shelter or tax strategy, because it isn't really a shelter, looks after, is by investing the tax savings in your own side account, your own investment account. If anything ever happens, because going forward, Revenue Canada does get nasty and changes laws. However, this has gone on for a long time, and because we're not actually writing off any interest, there should be absolutely no reason for CRA to even call and ask what you're doing. We also do suggest that the entrepreneur or professional take some salary, not a lot of salary, just a little bit of salary. Maybe
okay, Gord, I think that is about as much time
I'm
as we
sorry.
have. No problem. So I
Anyway,
think just in summary here, I think that what we'll point out is there's a lot of solutions, and Gord is referring to a leveraged opportunity that can allow you to benefit. Life insurance has what some would say is an almost sacred status in the Income Tax Act, insofar as there's no tax on death benefits, there's no annual accrual taxation, there's a lot of different reasons. But what we're describing here really is tools that can be used to achieve various different things. The chart that we can see demonstrates a tax savings of $4.6 million through an estate freeze, and perhaps an additional of $2.5 million. The very bottom box that we can't see demonstrates somewhere in excess of, there we have it, $7 million in tax savings. So sometimes we have individuals say, what does it cost to do an estate freeze? What does it cost to do tax planning? Well, in reality, it costs much more not to do planning. The fact is, it costs millions of dollars more. To us, we look at it this way. If this company has $5 million of cash that's inside of a company, and then they don't need to take it out, they don't want to pay the tax, by allocating a very small percentage of that, can avoid millions of dollars in tax. And not only that, but there can be asset protection, and there can be reductions in other types of tax on passive income. To that end, I'm going to say that our consortium is here to help when it comes to accessing funds from the federal government through the Scientific Research and Experimental Development Program. If you're requiring financing for the purposes of achieving growth, then the consortium has the tools to help you. And in the event that you are interested in mitigating the effects of tax by reallocating part of the money that you're not taking out anyway, and kind of having the effect of multiplying it times a much higher number, then there's opportunities that can assist you. So this seminar today has been in response to what can be done for the companies that are doing well. Up until now, the last 12 programs we've had have been based upon how to safeguard what you have. So I hope that you've enjoyed that part. Now there's another section that we'd like to introduce to you, and there's a growing trend in the United States with respect to costs and legal fees, particular accounting fees. And I would like to call on Daniel, if you please, just to kind of give Daniel Kim to give us an idea about what's happening in the United States. And we'll end up finishing the program in the next few minutes. Daniel, please.
Thanks, Todd. Really appreciate it. Yeah, for those of you who haven't met me or haven't seen me on these, I'm the co-founder of a legal fee advisory firm called Fee Simple Canada. And so we work with corporations and law firms really to promote transparency and best billing practices. And as Todd mentioned, kind of want to speak to the trends that are happening in the US that have implications coming towards Canada. One of those that I think we're all fairly familiar with within the legal industry is alternative legal service providers. Specifically ones that are growing in the US are legal auditing companies. And so one figure that I think of is a survey in Thomson Reuters finds that 25% of corporations are going to start using ALSPs, alternative legal service providers, to help manage the legal departments. And so we've seen a client-led movement towards fee transparency, whether it be fixed fees or value pricing. And along that legal value chain, we find that a number of CLOs are being pressured to lower costs and demonstrate productivity in specific ways. And so we know that there's a lot of pressure for accurate legal budgets, in terms of forecasting and having some element of predictability. And so, the CLOs we've worked with are, really looking to stretch their budgets internally and to lower their dependence on external counsel. So as it relates to, a lot of the attendees today, whether, accountants or lawyers, I'm certainly of the view that, lawyers and law firms will be better served to work with their clients to adapt to these types of circumstances. And firms can proactively introduce billing guidelines to increase transparency, with their clients. And they can also establish relationships with ALSPs and legal auditors to bring a third-party perspective to potentially contentious disputes over invoicing. That way, the law firms and the lawyers can really focus on the legal and business issues without having to muddy those waters.
Excellent. We thank you for that. We appreciate, Daniel, you making us aware of what's happening, particularly in the US, and what seems to have been happening in Canada to perhaps a lesser extent. What can lawyers do to protect themselves other than, as you say, work with lawyers? Like what should lawyers be expecting, law firms expect to see this way?
Well, I think a big thing will be kind of pushback on different practices where, something like block billing or perhaps some ambiguity as to kind of how invoices are being submitted and how invoices are being reviewed. And so I think that's one area where lawyers can really look to kind of shore up their own kind of best practices, either by going by their internal policies or reaching out to third parties to get a sense of, what the industry standards are that, that clients are really expecting now.
Yeah, thank you very much. And we noticed that it's just coming up to the bottom of the hour, and it is our policy to always finish on time. On behalf of the entire group of the Quantum Business Law Consortium, we remain committed to your continuous education. If you're an accountant or a lawyer, we have a program referred to as Tax Assist and Litigation Assist, where we provide complimentary advice on tax and litigation matters, including all of the subjects that you heard today. We'd be delighted to spend time with any of you as the service is complimentary, and we provide advice on these issues. Preliminary advice, yes, without a charge. And this is an offer that's been extended to all of you in attendance. We appreciate your time, and we wish everyone a very pleasant afternoon.
Thanks, Todd.
Thank you, everyone.
Thank you.